All right, welcome. It, Thank you. I'm glad you. Looks like I had to pivot this morning just out of the abundance of precaution, and I've decided to do a Zoom. Also, I'll be recording this Zoom for my other section as well, so they can have a reference. I'll take advantage that we're going to be talking about the common law. So what I want to do, because we have such a short period of time, is introduce you to this module C, the common law. And what we're going to be doing is looking at the complaint that the Winklevoss twins brought against Mark Zuckerberg in 2004, played some music from that era, so that you can get a flavor of the common law in action. The original complaint that the Winklevoss twins, or that their company ConnectU, brought against Zuckerberg and his co-founders. I've included that in the modules or in the files. You'll see that complaint. It's based entirely on common law claims. In fact, before we jump in, what I've decided to do, so it's not just me talking. I know Zoom can be a real, I'm not a huge fan, I'm going to be honest with you, but it's sort of like a second best proposition right now. What I'm going to do is I did create a presentation here. So what I'm going to do is I'll pull it up to make it entertain. This is just to make this class as entertaining as possible. Again, this will be an introduction to the common law. We'll delve further into this. My honor section will delve further into this next week. But let's go ahead and let me see if I can do a screen share. Great. So I'm going to go ahead and do a screen share and share this presentation on the common law. And I certainly invite you to go and check the Winklevoss complaint for yourself. I think with, in its entirety, it's about 12 pages, double spaced, if I'm not mistaken, and including the signature page, and you can see the law firm that brought the action. What I want to do, though, here is just focus on, and by the way, in a future module, we'll look at sort of the process of bringing a lawsuit, what lawyers call litigation. We'll look at civil and we'll look at criminal litigation. Thus far, we saw in Module B, the main sources of law, looking at cybercrime as just an example to illustrate the main sources of law. And then, Module A, we looked at business in the Constitution with an emphasis on speech rights. So here, though, I want to look on the common law. And here, I took a screenshot of the complaint that the Winklevoss twins brought. This is paragraph number 1. And what's really beautiful about this complaint is that it just lays out all of these common law claims. And we'll see how deep we can get into it today. I'm going to talk about really the 3 main allegations. Theft, you stole our idea. If you saw The Social Network, that's sort of like the theme of the movie. That's the Winklevoss twins sort of main complaint, if you will, or main accusation. But what the complaint does, it lays it out from a more lawyerly fashion. And in addition to theft, or what we call misappropriation of trade secrets, there's also a breach of contract claim, as you can see there. There is a claims for breach of fiduciary duty, unjust enrichment, interference with a prospective advantage, or interference with a contract, and lastly, fraud. What's nice about this complaint is it shows us sort of the 3 main areas of the common law that are most relevant to business. And so it's no coincidence that this complaint really encapsulates these 3 great areas: property, which is this idea of theft. Trade secret can be a type of intellectual property. Breach of contract, idea of a broken promise and legal liability for the broken promise. And lastly, fraud, which is a part of the common law called tort law, when you intentionally or unintentionally injure somebody else. And so now one of the things you'll look at, the very the 4th and 5th words of this complaint is that or the first 5 words, this is a civil action, right? So unlike what we saw, for example, in Sources of Law, where I focused on cybercrime and possible criminal liability, a criminal prosecution, whether it be a state-initiated federal case or an extradition under an international treaty, the Budapest Convention. Here we're looking at civil liability when one party is suing another party for monetary damages, to collect money in repayment of injuries caused. And these injuries could be based out of property. You stole my stuff. These injuries can be based out of a contract or broken promise. You lie, you broke your promise to me, or these injuries can be based on or these remedies can be based on tort law, or tort injuries. You lied to me, or you injured me in some other way. So the common law really overlaps in a really powerful way with, going back to morality and theories of ethics. There's an overlap. But what we're going to see in this particular class, really focusing on theft, property, and contracts, torts, property, and contracts. We're going to look at also the differences between our moral intuitions and then the common law, and how the law defines these wrongs. So just consider this an introductory class on the common law, using this complaint as an introduction. Now, before I jump in, I do want to share with you my favorite quote from Oliver Wendell Holmes, or one of my favorite quotes. Oliver Wendell Holmes wrote this beautiful book called The Common Law, which is more of a history book, and where he sort of describes the development and evolutions of these major common law institutions of tort, property, and contracts. And his famous quote on the very first page is that the life of the law, and here he's referring to common law, judge-made law, as opposed to legislation that we saw when we talked about sources of law in the previous module. He's talking about judge-made law. That's what we mean by the common law. But what's really cool is, before we jump into these specific areas of common law, Holmes is saying that the common law is, because it's judge-made, it's based on experience and not logic. That the law, there's a popular misconception that the law is something logical, or, based on deductions or axioms or syllogisms, things that you learn, for example, perhaps in, logic, or that branch of philosophy called logic. And while certainly a lot of law, can have that aspect to it, but at the end of the day, and I think you're going to see it here when we look at the Winklevoss complaint, when we have to actually apply the law to facts, you're going to see the common law, again, just borrowing Holmes' quote, embodies, a nation's history. What's really cool about this is it means that culture is really important in understanding law. And so I just throw that out there sort of, again, as an introduction. That's why I like to play the music from that era. All of these influences, all the stuff that's going on in the world, all the stuff that's going on in our nation help inform decisions made by judges when they decide cases. And so that's why I really, and it's not just me, this is a really famous quote about the common law. All right, and it's one way of distinguishing sort of from legislation. If you think about it, think about legislation, right? When we talked about, for example, the Computer Fraud and Abuse Act, or Section 33A of the Massachusetts Criminal Code, or even the Budapest Convention. Think about law is really just legislation, just it's part of the political process, right? It's usually, to get a law passed, it's gonna have to be compromised, you know what I mean? Among different political factions and political parties and ideologies. Whereas the common law, this judge-made law, supposed to ideally transcend politics. And so I just want to throw that out there just by way of introduction, that this is a really, really special area of law. Now, to what extent does the common law, because it does embody our culture, our history, our values, to what extent does it embody, transcend politics and that kind of stuff? Those are deeper questions, of course, but I just want to throw that out there. One more thing about the common law. Remember, I keep saying it's judge-made law. Historically speaking, and Holmes gives a lot of examples in his book on the common law. The great common law synthesis or treatise is going to be Sir William Blackstone from the 1700s. He wrote this 4-volume magnum opus, sort of summarizing what he called the laws of England. And it's really just common law. And you can see here, I got a quote from, the great Sir William Blackstone, saying that common law, you're going to find it not in a code book, it's not like a treaty, it's not like a federal law, it's not like a state law or local law. It's in the records of our judicial decisions, so it's judge-made law. And we're going to see that these principles and doctrines and rules that judges have enunciated, developed, and refined over the years will form these these great 3 big bodies of private law, torts or injuries, contracts and broken promises, and property and theft. And so just want to throw that out there so you have some sort of historical picture that, this is our common law tradition going back to England in the Middle Ages, really going back to the great Henry II. I think this is the 12th century, AD. Henry II, the idea is it's called the common law. Let's have, instead of having a bunch of different courts, an ecclesiastical court, a law merchant, feudal and baron courts, let's have a single law for the realm. You know what I mean? Back then, the parliament wasn't as powerful. So what Henry II and his descendants did is appoint began with 6 or 7 judges, and they would travel all across England deciding cases. You know what I mean? Eventually, this would spread to Wales and Scotland and Northern Ireland, United Kingdom. But it really begins in England, and it's this idea that we're going to have a group of judges appointed by the king, so that the king, there'll be somebody there to enforce these decisions, but it'll be a common law, common to the entire realm. Now, what's fascinating, I want to say one more thing about the common law to show you just how special it is, and why I like to harp on it. Oops, let me just close this. Sorry about that. Where is my arrow? Here it is. Common law, because of the British Empire and England, Britain conquered all of these places in Africa, North America, Asia, and Australia, New Zealand. The common law actually is a lot of countries, not just the United States and England. A lot of countries actually share the common law tradition. This idea of judges playing a really important role in applying the law to facts, in developing, announcing legal principles, following precedents, et cetera, et cetera. Now, granted, all of these countries, they'll have their own particular common law traditions and their own particular common law evolution. But what's fascinating about all of these countries, as different, there are even Caribbean countries out here like TNT, Trinidad and Tobago, Jamaica, Bermuda, Bahamas, countries, all the original 13 colonies. The idea is that, in countries that were colonized by England, what happened is that the courts ended up playing a really important role. And even like in countries as countries as you would think as different, as the United States, like let's say India or Pakistan in South Asia, there the courts are common law courts. The judges play a really important role. The courts operate in English, and sometimes they'll cite precedents from England, in order to fill gaps in their own, when they're deciding cases. So it's a really, really amazing tradition that transcends, a lot of different countries. But because of United States' particular history, United States inherited the common law tradition. And even after the so-called, the American Revolution, 1776, independence, and the new Constitution, there was a lot of stability at the state level in that the states continue to follow with the common law tradition. One of the things we'll see after this lecture, and I'll put in module C, is some of the great common law cases in property, torts, and contracts. But now what I just want to do is focus on, one more thing about the common law. I have to give you one more introduction. If any of you are interested in law school, this is basically what you study in your first year of law school, contracts, torts, and property. in some law schools, property could be a second-year course. But one of the things about this too that makes it quite challenging to teach at this, at a survey course introduction level is like take contracts and torts. At most United States law schools, those are 2-semester classes. So what I just want to do is give you an introduction to these 3 great areas of law, of common law, and just tell you sort of the most important aspects. And here's what we're going to be doing. What I've done is I've taken the Winklevoss complaint. I showed you the screenshot. It's in the files. You can look at the complaint itself, alleging breach of contract, theft of trade secrets, fraud, etc., unjust enrichment. And here what I've done is I've sort of translated these things into just into plain English. So you can see, for example, misappropriation of trade secret, just a fancy way of saying you stole my idea. Breach of contract is you made a promise and then you subsequently broke that promise without any justification. Fraud would be you lied to me. And there's that great scene in the Social Network where I think Divya Narendra, the partner of the Winklevoss twins, said, yeah, he lied to our faces, referring to Zuckerberg. Also, the complaint refers to unjust enrichment, ill-gotten gains, and there's also a reference to fiduciary duties. This is a very special sub-area of law when there's a principal-agent relationship. But what I want to do is really focus on those first 3, theft, breach of contract, and fraud. I just put together this presentation, so we'll see what order everything comes in. But let's just jump in. Okay, so let's jump in with theft and this idea of not stealing. So here I'm going to be brief on the trade secret theory of the case here. My main thing is just to show that the Winklevoss case is not frivolous, and just to show you how the common law might apply to any given set of facts. But in our next module, Module D, we'll look at the law of ideas, and we'll look at trade secret law head on. But here, what you want to know is that trade secret law is common law. It's common law. It's basically a set of principles enunciated by judges saying when, what are the conditions for when you can have legal ownership of an idea. So it's common law. And so in the United States, common law is basically state, judge-made state law. I will tell you as a quick timeout, there's something called the American Law Institute, which is a private body. It's very prestigious for a law professor to get appointed to the ALI. And the ALI has published something called the Uniform Trade Secret Act. And the Uniform Trade Secret Act, sort of model law based on the common law of England and the United States. And many states have adopted sort of the Uniform Trade Secret Act as a type of legislation, state legislation, but that legislation is based entirely on common law principles. And I can tell you, the Commonwealth of Massachusetts, or the state of Massachusetts, is not a Uniform Trade Secret Act state. It still is hardcore common law. But one of the things is whether the state has adopted this Uniform Act or whether they're just pure common law. One of the things is that a trade secret, there's lots of different ways of stealing or misappropriating. That's why the common law talks about misappropriation. It's not just outright theft, which is what, arguably happened or is depicted in the Social Network. It's not just acquisition by improper means, also acquisition by accident or mistake. So one of the things you'll notice if you look at the complaint that the Winklevoss twins brought against Zuckerberg, they also sue, if you look very carefully at the caption at the very top of the first page, they also sue every single co-founder, Chris Hughes, Dustin Moskovitz, Andrew McCullum, Eduardo Saverin. That is to say, if any of these individuals acquired, even if it was by mistake or accident, the trade secrets of the Harvard connection or Connect You, the ideas that Zuckerberg is alleged to have stolen. And frankly, it seems like it's a pretty much slam dunk case, stole their ideas, So even if you acquire something by accident, if it's not yours, it's theft. And so common law, look how broad that trade secrets and misappropriation of trade secrets are defined. And it's also use of or disclosure of a trade secret. So even if you have, let's say Zuckerberg was authorized to look at the Harvard connection code and all that, computer source code, and so that he didn't acquire it improperly or by accident. Remember at first he was, there was this whole informal agreement that he would help them with the website. But if subsequently you use it, or disclose it, like to one of his co-founders, improperly or in violation, as you can see there, of a duty to keep it confidential, that's also defined as theft or misappropriation. Again, what I want to show you here is not to prove conclusively, one way or the other, but to show you that the case that the Winklevoss twins brought is not frivolous at all. Now we'll look at trade secrets in the next module. I don't want to get into it here, but I just want to show you that the common law defines theft, in a way more broadly than maybe our moral intuitions about what is theft and what is, can you actually steal an idea? It's one thing to steal physical property, but can you steal someone's idea? And the common law says yes, and you can steal it by accident, or by disclosing it in an improper, unauthorized way. So just want to throw that out there, that, and that's why it's no coincidence that the Winklevoss complaint begins with misappropriation of trade secrets, one of their strongest claims. What about the other claims, though? And so let's talk about some of those other claims here. Okay, fraud. I was hoping to do breach of contract next, but we can do fraud next. And I have here that I found this quote, like pop psychology, like a good relationship, don't lie, don't cheat, don't make promises you can't keep. So we have we have maybe a moral intuition of what fraud is. It's basically a knowingly making a false statement. And here's sort of a simple play example, of clear-cut fraud. Often in this is called passing off or counterfeit goods. When you knowingly sell something, like a fake Chanel bag is the example I have here. You know what I mean? So it's these bags are very expensive, and so there's thriving underground or gray market, if you will, and so it's a classic sort of example of fraud, right? And to that extent, it kind of coincides with our moral intuitions. By the way, can I do a quick timeout? Fraud, right? It can also be a crime, right? It can also be a crime, but it can also give rise to civil liability, right? And fraud, or as it's formally called, fraudulent misrepresentation, is considered a tort. That is to say, it's a way, like theft, it's a way in which you can injure someone. Whereas theft is, you have to have pre-existing property rights. The property right could be in an idea, like a trade secret. I would argue that the source code for Harvard connection would be a valuable trade secret. And so Mark probably stole that. That's a strong claim. What about fraud? One of the things too is before we actually evaluate fraud and show, how strong it is, when you look at the business world, there are some of these spectacular cases of almost systemic, huge fraud at the highest levels of some of the most, top business firms in the world. Or in the case of Bernie Madoff, I put him there because there's a new movie with Robert De Niro out called The Wizard of Lies, and excellent movie. I just happened to see it recently. Largest Ponzi scheme. That's what we normally think of fraud, right? That sort of intentional deceit. And you can see, right, that's sort of a big time case of fraud, but look at all these other examples, and I'm not going to belabor all of these examples, but I do want to, what I do want to do is bring them to your attention. And by the way, just a quick recap, Volkswagen, they're alleged to have, basically falsify their on their diesel automobiles, whether those automobiles actually comply with these very stringent legal standards, for example, in California for emissions, Enron is probably the most famous case after Bernie Madoff, Wells Fargo, the phantom accounts. FIFA is really interesting. The international governing body of soccer. This is the most popular sport in the world. The feds brought a huge anti-corruption, bribery, extortion case against the highest levels of FIFA. In fact, the previous president of that organization had to resign under a cloud, and a lot of his top level people were accused of accepting bribes and stuff like that in order to host certain games in certain countries and stuff like that. But so I want to, what I do want to do is, rather than going into specifics, and we can give even more examples, of everywhere in between. These are some of the most famous examples of business fraud. Is I do want to generate a question that sort of like, are these just a few bad apples, or is this the tip of the iceberg? In other words, how pervasive, how common is fraud in the business world? Because that will show you then the common law of fraud, in addition to whatever federal statutes that might exist, and state statutes, is going to be very important in helping us to police and deter and, generate legal consequences for fraud. That's a tough question, right? So I don't know specifically the answer to that. I will say, though, when you look at other competitive areas of the world, and the sports world is what comes to mind, although sports is generally zero sum, right? Every game, unless it ends in a tie, there's a winner and a loser, right? Business is not necessarily, rarely is it zero sum, right? If it's not fraudulent. Business is supposed to be based on these win-win transactions, you know what I mean? Or mutually beneficial transactions. But nonetheless, business is highly competitive, what I'm saying. And but what's interesting is, in the sports world, you look at all these various examples, whether we're talking about cycling, 7-time, Tour de France winner Lance Armstrong, Ben Johnson, Olympic gold medalist, Tom Brady, GOAT of all time, Mark McGwire, single season home run champion, or the entire Russian Winter Olympic team, you name me a champion in any single sport, and I'll name you credible allegations of cheating, fraud, et cetera, et cetera, et cetera. Right. So again, is this a coincidence? Is this, I throw it out there as a, not as a rhetorical question, but as a sincere question. Are these just, a few bad apples, or in fact, is this the tip of the iceberg? Is cheating and, breaking the rules and performance enhancing drugs and all that, is that actually par for the course, or is that why these guys are champions, ladies? Because in fact they are breaking the rules, so they have that added advantage. So again, that's a really interesting research question. I even say, before we do the common law, even in daily life, we lie about Santa Claus. You know what I mean? And so it's this myth and stuff like that. And to what extent, to some extent, we all engage in some level of deceit. You know what I'm saying? Maybe there's morally justified reasons for doing so. Maybe lying is never or rarely morally justified. We'd have to go back to the theories of ethics. But what I'd rather do here is just focus on the common law. And notice what the common law does. And this is where I want to show you where maybe unlike theft and misappropriation of a trade secret, notice here, right, to prove fraud, actually showing a false statement or a false representation. Sometimes withholding information can also be considered fraud if you have a duty to disclose. That's just the first requirement of a long list of requirements. Now, the common law, because it's state judge-made law, this could vary state by state. Some state judges and some state courts, they might organize or word these elements in a different way. I'm just borrowing what's called the Restatement of Law, again, published by the American Law Institute, which purports to give sort of a summary of the common law of fraud. And what you see is, when you look at the common law and you look at all the different state courts, and you look at the law of England, and you look at even law of other jurisdictions, that borrow the common law, what you see is that, first of all, the false statement has to be a material fact. So it has to be something that, that's really essential to whatever the underlying transaction is. So it's got to be and right there, this limits opinions, right? Opinions, false opinions are not, don't generate legal liability. That's one of the interesting things about the common law. So a lot of fraud cases, whether they're brought under criminal statutes or whether they're brought under common law, like the Winklevoss twins to collect, money damages, a lot of the litigation will be, well, was there a misstatement? And then, and was it on a matter of material fact, or was it just on an opinion? So when Mark Zuckerberg basically lies and says that the Harvard connection is not functional, is that an opinion or is that a material fact? I would argue it's a material fact, but maybe functionality, what do we mean by functionality? When we're talking about a computer program and a website, the movie doesn't really go into a lot of the detail here, but I can tell you from researching this stuff that the Harvard connection, it was actually at one point in time operational on Mark Zuckerberg's laptop. Like he actually did complete the code and got it up and running, it was never launched. But for Zuckerberg, it wasn't functional just because he didn't like sort of the graphics, but to the extent that could be, that with further coding and further work that could be changed and improved upon, it's one thing that a site is not functional, just it doesn't work at all, or, it can be improved upon, so there's that issue there. But my point here is, however you look at this, fact or opinion, and even if it's a matter of fact, it's got to be a material fact. Although I would argue that the functionality of the Harvard connection or connect you is a material fact, but notice that's just one requirement, one element. The person who tells the lie, he has to know that he's telling a lie, So again, that coincides with our moral intuition. This is a little bit different from trade secret theft, where you can accidentally, steal someone's property. You don't know it's somebody else's idea, but you use it without permission. But here you have to know that what you're saying is false. But there's a further requirement, not just knowledge, but intent. This is especially relevant when there's a criminal prosecution. This is often referred to as Cienta, the Cienta requirement, but just a fancy Latin term for intent. You have to actually know, like this creates a paradox. If you actually believe you're telling the lie, but you believe the lie to be true, you could probably then, escape both criminal and civil liability. If you're able to persuade the jury that you didn't really, believe in it yourself. Number 4, the fourth element, is probably the trickiest one. In common plain English, I would call that blame the victim element. If the defendant, the person being sued for telling a lie or engaging in fraud, if they can prove that, actually, burden of proof is on the plaintiff. The plaintiff has to show that, his or her reliance on the false statement that was made intentionally and knowingly, it was justified or reasonable to rely on the false statement. In other words, in plain English, you have to do your homework. You just can't believe people when they make statements, you have to do a little bit of your own homework and kind of verify, before you can sue somebody for saying that they lied to you. That's really how you can satisfy that reasonable reliance element. But I throw it out there that, it makes it kind of difficult to sue. And finally, last but not least, there has to be loss. In other words, and let me tell you this, this is really important. Here is where I think the common law generally, really, really differs from morality or theories of ethics. Whatever type of ethics you believe in, virtue ethics, Kantian golden rule ethics, or consequentialist ethics, or John Rawls contractarian ethics, whatever theory of ethics you believe in, telling a lie is generally in and of itself the injury, but legally, telling the lie, even if it's intentional, knowing, and it's reasonable to rely on it, is not itself, unless you can also prove economic damages, economic loss. And I'm going to tell you personally, here's where I think the Winklevoss complaint might run into a little bit of problems, because I don't dispute that Zuckerberg lied to the Winklevoss twins. I think, if the movie is to be believed, and it's based on the allegations and the complaint, based on information provided by Zuckerberg's best friend, Eduardo, all this kind of stuff. I think a reasonable case can be made that Zuckerberg lied, and he lied knowingly, intentionally, and, that it probably was reasonable to rely on him, on his false statements, because Zuckerberg is the expert here. But one of the ironies is that Facebook, a lot of new startups, they don't make money right away. Sometimes it can take years before a startup can make, even one as popular as Facebook as it was back in the day. Get 1 million new members, just less than a full year before after the website is launched. By the end of 2004, it's actually one of the fastest growing, startups ever, in the history of Silicon Valley. And even Facebook didn't make money for quite a while, so it's like, so if Connect You or Harvard Connection had launched first, what are your damages? I mean, Facebook is not yet making money. Maybe eventually they make money. How far in the future? Well, there we'd have to look specifically at, fraud cases in the jurisdiction in which the case is brought, just to see, okay, how do courts deal with that kind of a problem when a fraud has been committed, but there's no damages? Generally, courts will dismiss that as a matter of law. They won't even send that to the jury. That's going to be a problem. At the same time, I can say in defense of the Winklevoss twins, this case went on for years. And, by the time the case, and we'll see, it will settle out of court, but had the case gone to a jury, by the time the case was ready to go to a jury, Facebook was starting to make money. So maybe a case could be made, there. So I just want to throw that out there, notice how fraud, common law fraud, it overlaps our moral intuitions about false statements, but also it's not a perfect overlap, you have to, with common law, you have to satisfy all these series of elements, The main point, bottom line is this. Notice there's a huge asymmetry. And what I mean by that is for the Winklevoss twins to win, to prove their case, they have to prove every single one of these 5 elements, every single one of them. For Zuckerberg to win his case, for him to defend himself successfully, all he has to do is refute any one of the 5 elements, not all 5. For example, if I'm Zuckerberg, I'm going to focus on that element number 5. Even if, assuming for the sake of argument, obviously I'm going to contest every single one of the elements, but all I have to do is prevail on one of the elements and I walk home scot-free. Zuckerberg, the Winklevoss twins, they actually have to prove all 5 before they can collect any damages. And so you can see there's that built-in asymmetry, in the common law, a little bit different from our moral intuitions, a little bit more stringent. I would argue maybe that's a good thing, because then we could, to the extent we lie, on a daily basis, and commit fraud and that kind of stuff, it's good to know that maybe it doesn't rise to the level of a common law or fraudulent misrepresentation, or you could argue the reverse, maybe that's why you see so much fraud, because, it's hard to prove fraud. So I just want to throw it out there, that the research question I posed originally is kind of related to how the common law defines fraud. But as you can see, this is a really important business tort, probably the most important of the business torts, given that, even if fraud is not that frequent, even if it's not the tip of the iceberg, it's just, a few bad apples, you saw that it does occur at the very highest levels, what I'm saying? And if it does occur more frequently, if it is just the tip of the iceberg, it's all the more important. All right, finally, and I will do a quick time check here, because I want to cover, there's a lot to cover, and I want to take advantage of this first introductory class. I want to at least cover one more really important business common law claim, and that is going to be breach of contract. This basic idea, and this little quote here really captures that, in some ways, breach of contract can be described as a tort at a theoretical level, because, when you break a promise, it's kind of like telling a lie, and it's kind of like, it's sort of an extension of business fraud. But at common law, breach of contract and contract, it's a whole separate other area of the common law based on voluntary agreements, based on voluntary promises. And what's really interesting is, from a moral point of view, you can argue that breaking a promise is qualitatively worse than just telling a lie, because telling a lie is bad enough, right? Whether you look at it from a common law perspective or you look at it just from a pure moral perspective. Breaking a promise that you specifically make, right? So you create this false sense of hope or expectation in the other party, what the common law calls the promisee. You could argue that's even worse, because not only are you lying, but you're setting somebody up, you know what I mean? So you could argue it's qualitatively worse. But what's really interesting is, and here's sort of a brief elements of contracts. The common law is going to be a lot more technical. Here, the common law is going to establish a number of elements that have to be shown. In other words, not every promise is legally enforceable. And that's going to be the important lesson that we're going to learn for the end of this class, end of this lecture. Not every promise is legally enforceable, only a very small selection of promises. So let's look at that. Now, before I look at these elements of a contract, I do want to say that breach of contract is a little bit like theft in that, or misappropriation, in that, it doesn't matter if the contract is verbal or not, an oral contract. Oral contracts, the general rule is that they are fully legally enforceable unless they fall into any one of these specific exceptions here that I have listed on this slide. And the main thing about this slide is that you just, this is really probably as technical as I'll get here, is there's really two types of contract law. There is the common law, of which a branch of it is the Statute of Frauds, which I'll talk about in a moment. And there's something called the Uniform Commercial Code and contracts for the sale of goods. The Uniform Commercial Code, again, it's a model law adopted by the American Law Institute, this private organization, very prestigious, with judges and law professors and prominent attorneys who are invited to join. And most states, actually all of the states, have adopted, with minor variations, have adopted the Uniform Commercial Code as a matter of legislation at the state level. Now, this doesn't really apply to the Winklevoss or Connect You, because the UCC applies to the sale of physical goods or contracts in which goods predominate, In the case of the Winklevoss twins and Mark Zuckerberg, there it's really, we're talking about the performance of a service. Zuckerberg is going to promise to help them out with their website. One of the things I can't show you here because of the screen share, but I'll try to figure out and put it in the module. I do have a clip from 60 Minutes back in the day. I think this was 2010 when the movie came out, or 2011, where Zuckerberg does admit on national television, he says, quote unquote, I agreed to help them, the Winklevoss twins, out with their website. So we're gonna have a full confession, that he did agree to help them out. But it's to perform this, or finish writing the code. Statute of Frauds, it's called Statute of Frauds because these judge-made principles were ultimately adopted by the British Parliament as the Parliament became stronger. But it was originally, all of these were judge-made exceptions. So some types of contracts do have to be in writing. Like in the Middle Ages, a promise to get married was a big deal because you have these two powerful families coming together, aristocracies, and so that needed to be in writing, for example. The other big one that for today would be like real estate transactions, any contract involving the sale of land, would have to be in writing. So real estate transactions generally need to be in writing to be enforceable. But the point is that these are the exceptions to the general rule that, verbal agreements, verbal promises are legally enforceable if the person, the plaintiff here, the party who said, hey, this other guy, Mark Zuckerberg, made a promise to us and he later broke the promise, if they can establish these 4 elements. You have to show there's a voluntary agreement, offer and acceptance, right? Here, I'll put in the module the film clip with the 60 minutes interview. I'll tell you what part of the interview, I think it's like a minute 12, as you don't have to watch the whole thing. But minute 12, Zuckerberg basically admits, I agreed to help them out with it. So we have the voluntary agreement. The basic idea there is that, if there's coercion, if there's duress, if there's fraud, that's not a voluntary agreement. That's not an agreement based on voluntary consent. So the consent has to be voluntary and informed. There has to be something called consideration. Something of value has to be promised. A thing of value. You just can't make what's called a naked promise. You actually have to promise to give something of value. And there has to be contractual capacity. In the case of Zuckerberg, he was 19 years old at the time that he met the Winklevoss twins and agreed to help them with their website. So he's no longer a minor, not going to be an issue here. Lawful object. So there have to be, the contract cannot be for something improper or something unlawful. Here I have further, this is a little bit complicated. It just goes to, but I want to give you a flavor of how lawyers look at a contract. We don't just look at, did you make a promise? We have to look at all these 4 different aspects. Capacity can become an issue when you're dealing with minors or persons that have impaired mental capacity, or persons who have a temporary mental impairment, maybe under the influence of alcohol and stuff like that. So those always become questions of degree. Even a minor. Minors are, contracts with minors are perfectly fine. Actually, this is a little bit incorrect. But the minor, when he does or she becomes 18 years old, or in some places, some common law countries, it's 21 years old. They have a right to back out of. They have a right of rescission. Which normally you don't have. But we always look at capacity. Legality is an issue. If the Harvard connection, does it break any of Harvard's rules? In this case, it doesn't, but I can tell you for a fact, there actually was a student called Aaron Greenspan. He was a classmate of Zuckerberg's and the Winklevoss twins. He actually came up with the very first Facebook. He had something called the Universal House System that was designed to unify all 12 of the houses. And his website, it wasn't as clean and simple, to borrow the movie The Social Network, as Facebook was. But among the things that were on his website was a Facebook-like tab to it. The problem with his website is the university made him shut it down, because his website also had another tab that allowed you to access your Harvard email account. But in order to do that, in order to use, sign up for the Universal House System that Aaron Greenspan had built over the summer of 2003, you had to use your harvard.edu password. And Harvard said, no, that's a violation of Computer Fraud and Abuse Act. That's illegal sharing of passwords. We're going to shut that down. We don't want to incur any legal liability for that as a third party. So they made Greenspan shut it down. And in fact, I can tell you for a fact, the scene in The Social Network, one of the most compelling scenes, when the Winklevoss twins go to meet with Mr. President Larry Summers, Dr. Summers, that's actually based on a meeting that Aaron Greenspan had with Larry Summers in October, right before the whole face smash incident occurred. But anyway, I won't get into any of that right now. What I do want to focus on is consideration. Here again is where the Winklevoss case might fall apart. Because while Mr. Zuckerberg is offering something of value, he's saying, look, I'll help you out with your website. I'll do the computer programming that's necessary to finish the source code, and get your site to be functional or operational. What's the consideration? What's the thing of value that the Winklevoss twins are providing Mr. Zuckerberg? In the movie and in real life, the Winklevoss twins simply say that, hey, Mr. Zuckerberg or Mark, this is a great chance for you to rehabilitate your reputation after the face smash fiasco. You know what I mean? The problem is, how is that a thing of value? You know what I'm saying? Generally, things of value have to be well defined. You know, it's got to be, for example, I'll give you two examples of something of value. Here's a dollar, Mark. It's symbolic. I know a dollar. This is worth way more than that. But here's a dollar, you know, in exchange for you, you know, to help us do the website that we want to build. A dollar is something of value. Or Mark, you know what? It's four of us, right? Divya, Tyler, Cameron, and you, Mark. Let's each have a 25% ownership stake, equity stake in this new Harvard connection, Connect You, right? That would be something of value because it's defined. You know, even though we don't know how much money we'll make if we make money, but you're getting 25% of that future revenue stream. That's what I mean by something of value. And the courts and the common law, one of the most famous doctrines, the doctrine of consideration. Courts do not really second guess the adequacy or sufficiency of consideration. Courts will only determine its existence. Is something of value being promised or exchanged? And this to me is where common law contracts diverge radically from the theory of, you know, morality of promising. You know, a promise is a promise is a promise, but at common law, a promise is not legally enforceable unless it's, you know, voluntary, fine, unless the parties have capacity, fine, unless the contract is for a lawful purpose, doesn't break any rules, fine, and unless something of value is exchanged. That's the big one. Something of value has to be exchanged or promised to be exchanged. A good example of this would be reward offers. If the reward offer, like you see a sign up there says, you know, lost dog, reward, call, you know, 407-123-4567, you know, if you find the dog, if that's all that says, that's not a legally enforceable promise. But if it says reward $100 or reward, you know, $20, if it specifies a specific amount, that is legally enforceable if you find the dog, you know, and then are willing to turn it in. So that's what I mean by consideration, something of value, well defined. What's fascinating about the common law, and it's just a lesson here that you can never go to court without legal representation. There's actually an exception. I don't want to belabor this. It's in the reading for Module C that I'll put in there. Promissory estoppel. It's actually an exception. So you just can't go into court yourself. You always need a lawyer, you know, whether you're suing somebody else or you're being sued. Because actually the Winklevoss twins, even though they're going to have a tough time proving consideration, if they have a good lawyer, they can tell the court, they can tell the judge, Your Honor, I would like you to invoke this exception, this doctrine called, again, judge-made common law. It's called promissory estoppel. It means, as a fancy word for saying, it means if I rely on a promise that you make to me, that you're going to help me with my website, and I rely to my detriment, even though I didn't give you any return consideration, I don't offer you $1, I don't offer you a specific ownership stake in this new business, but if I rely to my detriment, I might get the court to go ahead and send this case to the jury, you know, maybe even rule in my favor as a matter of law. You know, we'll look at how the legal system works, how cases play out in that last module. But I just want to show you out there, right? So that's why you need lawyers, right? And this is why the common law is so important, and is why lawyers have to be licensed on a state-by-state basis. Although now there's something called the Uniform Bar Exam that I think 37, 38 states are now joining. But the basic idea is that the common law, there could be minor variations in any specific state, you know, as to when courts will invoke this exception of promissory estoppel when there's no consideration. But notice it's really interesting, right? There's a rule, you have to have consideration, and there's sort of a narrow exception to that rule that if you rely on a promise, even if it's not supported by consideration, and it's to your detriment, you can still prevail for breach of contract if the other elements are met. On the Winklevoss twins, I'm going to argue, yeah, it was to my detriment that I relied on Mr. Zuckerberg's promise that he'd help finish our website, because, you know, it was to our detriment that we didn't get to launch first and we lost that advantage, you know. So notice there, the case then is actually not as weak as maybe the movie portrays it when you actually look at the complaint and actually look at the allegations. All right, let's end the screen share. I'll do a quick time out here for a time check. So we still have a few minutes left. What I'll do now is just open it up to a question and answer here. Oh, correlation between loss and monetary damages. You can also put your question in the chat. This is why, for example, tort law and even contract law are 2-semester courses. Because, for example, when somebody sues a common law claim, for example, theft, whether it's an idea or physical property. By the way, if you steal physical property, it's not only a crime, it could also be a civil liability tort. It's called conversion. It's how we lawyers talk about common law theft. But whether it's breach of contract or tort, right? The plaintiff has to establish 2 things. And sometimes a trial judge, if it's a complex case, they'll break up the trial into 2 phases. One will be called the liability phase, and one will be called the damages phase. This is generally for complex cases, usually involving environmental harms or harms like asbestos or, these kind of long-term harms that involve a large class of people. A case like the Winklevoss twins, which is a fairly complex case, probably will be just combined into a single. Liability means you have to show, did Zuckerberg lie? Did he break a promise, or did he steal, or did he do any one of those things, or all of those things? Now, of course, when we say lie, steal, or break a promise, we really mean it in the legal sense, right? That was there a legally binding promise that Zuckerberg then failed to comply with? Did he actually not just lie, but did he do it knowingly and intentionally? And it was reasonable for the plaintiff to rely on the, did you satisfy all the elements, basically, right? But then the second phase is damages and how do you calculate? So yeah, to answer the question, yes, loss, what we mean by loss is monetary damages. So, and this can become very, very tricky when a business like Facebook hasn't made any money yet, right? So, okay, you're alleging that the founder of Facebook committed fraud or, broke a promise, but then what is what is the remedy that you want? By the way, with contracts, it can get really complicated. You won't need to know this. This is especially for my the students in the survey class. You won't need to know, we're not going to do contract remedies here. That's a whole semester. But what I will tell you is that rarely will courts order the remedy of specific performance. Like that's the most common sense. You think if somebody lies to you and you prove there's a legally binding promise, it's a contract, and then it's broken, what's the remedy? Well, rarely will courts order Mr. Zuckerberg, okay, you have to finish the action. You actually have to go and finish the website, because you'd basically be forcing Mr. Zuckerberg to work for somebody else. No, what the remedy is going to be, again, it's going to be damages, economic, monetary, dollars and cents. But again, how do you calculate that? Whether the injury is fraud or whether the injury is a broken promise. And there it can get really complicated. Maybe the court will call some economists as experts. How do we quantify, the loss? And there are, I can tell you, you have to take my word for it. The common law courts have created various ways. It's a really tricky problem, and courts have created various ways of being able to help us quantify losses. But yeah, that's the bottom line. If you, the plaintiff, even if you were lied to, even if your stuff was stolen, even if somebody broke a promise to you, if you're not able to quantify those losses into an economic, measure, you're not going to be able to recover. And that's another reason why you need a lawyer that has, practice or, expertise in those particular areas, in the calculation of damages or in the figuring out what contract remedies are. I'll tell you, there's a very famous episode. One of my favorite shows of all time is Entourage, which used to be on HBO, and there's a movie out there. A great movie, great show. And there's one episode in which, it's the only episode in which the character of Turtle plays a significant role. And if those of you haven't watched HBO Entourage, Turtle is a friend of this guy, is a big time like actor. And Turtle, he decides to go in the entertainment business. He finds a mixtape by this artist called Bow Wow. I think in the show though I think it's called Saigon. And he finds a mixtape and he goes, wow, this is really good music. It's like, like the music we play with Fat Joe or, Eminem and all that kind of stuff. He says, I want to represent this guy and get him to, I want him to, I'm going to sign him up with a label. I'm going to figure out, where, and he finds out, there's this whole plot line. And the one episode, it's, I believe it's, they're about to sign, I think, one of these big Capitol records, stuff like that. And Saigon, the artist known as Bow Wow, he never shows up. And the thing about it is Turtle, his fee is based on this guy signing the contract. And Turtle did what he promised to do. I'll find you a major record label, and then you can break into the music business, and then you give me a finder's fee, Well, it turns out, and so in this whole episode, him and this other guy called Johnny Drama, the brother of this guy's close friend. They're all over LA trying to look for this guy. Grew up in LA, all these landmarks, and it's actually based on a true story with Suge Knight that happened in the early 90s, And the thing about it is, it turns out that Saigon already had a manager, and he signed with a hip hop label instead of a major label. He signed with like Interscope or Death Row Records. And, for him, that would be better for his career because that's the audience. He wants to break out and be part of that particular niche. And that's what was up and coming. And that's where all the big superstars were coming out. And so what's really fascinating is when Turtle finally locates Saigon, Saigon tells his manager, you know what, just give this guy the $20,000. I'll give Turtle the $20,000 I would have owed him, had I kept my promise. And so, and so courts usually, this is called expectation damages. Courts usually use expectation damages. If the contract had not been broken, what is the profit you would have made in order to reward you? When it comes to torts and injuries, how do you quantify? There it becomes a little bit more, you may need economic experts and stuff like that. Other questions here. So the Pepsi Harrier commercial, this is a great case. And in fact, this will be in module C. We're gonna after this introduction with the Winklevoss twins, what we're gonna be doing is discussing 3 great cases. Pearson v. Post, which tells us, it's a property law case, how can we ever own something? It's sort of a deep philosophical question. Very important, because without property rights, you can't have business. We're going to look at a tort case, Palsgraf. Palsgraf versus Long Island Railroad is one of the greatest cases of all time, because it tells us when there's an unintentional injury. Like, it's obvious, if you intentionally lie to somebody or injure them, false imprisonment, assault, whatever, battery, that's obvious that you have to pay damages. You've injured somebody physically, and we can try to figure out with medical bills, lost profits, lost wages. But what about unintentional injuries? What is your duty there? So Palsgraf is a great case. And finally, we'll look at Leonard v. PepsiCo, the Harriet Jet case. And we'll look at that in more detail. For now, I just want to say this for lack of time, is what the court says. What's interesting there is all the elements are met, but the court says that the offer of the Harrier Jet is a joke. It's a practical joke. It's a prank, and so it's not a serious offer. And therefore, we're not going to enforce this. So we'll say more about that case. You know what I mean? Because to me, I've never liked that case, because how am I supposed to judge when something is serious and when something is not serious? If it wasn't serious, why did Leonard basically spend $700,000 to redeem sufficient number of the 7 million Pepsi points to get the Harrier Jet? Right? That to me should be sufficient evidence that it is a serious offer, that somebody actually took Pepsi up on it, But you do look at the commercial, I think it is meant as a joke, so we'll look more at that, So it just goes to show you, right, that even though all the other elements were met, right, Pepsi was able to avoid legal liability. You have to understand, $700,000, a Harrier Jet is worth at the time over $20 million, and so it would have been a significant legal liability. We'll take more look at, that's a great case. And fraud, so fraud, and by the way, fraud, there's 2 ways fraud can be used at common law. That's why fraud is so versatile. One is with the Winklevoss twins. You lied to me, pay up, you lied to me, that caused me some damages, we'll calculate it somehow, and you have to pay me those damages. The other way fraud can be used is in contract to show the lack of capacity or to show the lack of a voluntary agreement. If the agreement that you made with me is based on fraud, then I can get out of the agreement. Here, though, notice the Winklevoss twins, they don't want to do that, right? They actually want to enforce the agreement, right? They want to say, no, Zuckerberg, you are not, it's kind of ironic, right? You lied to us when you said you were going to, help us with the website, but we actually want to enforce the agreement. So it shows you how versatile the common law is. You know what I'm saying? You can use fraud sometimes to get out of the agreement, to show that it was not, even if the offer was made seriously, it was induced via false pretenses, but again, you have to show all these elements. Or you can use fraud as just a standalone legal tort theory. I'm going to sue you independently of the broken promise for the lie that you told me. Another question here is, oh yeah, good. So everybody is good here. Let's do a quick time check. We still have a few more minutes. Any other questions, concerns? What I'm going to do here, by the way, is I'm gonna, no, I don't want to end the meeting. I do want to end the recording. Let me see if I guess I can't do that yet. Yeah, I'm gonna stop the recording and